Good evening, everyone, and thank you for joining us for another one of our Club Support legal webinars. If you joined us last week, we covered the basics of employment law, and tonight is a continuation of that, looking specifically at volunteers and 0 hours contracts. My name's Nia Parsonage and I manage Owen Mitchell's partnership with England Rugby, and I'm joined tonight by my colleague Sabile, who is a partner in our employment team, and Dave and Alex from the RFU's club management team. We want you to get involved in the conversation tonight, so it's not just a listening exercise. If you head to slido.com in a web browser and join our event using the hashtag RFU1308, you'll be able to answer the questions Sabile will pose to you when the time comes. If throughout the session you have any questions, there is also a Q&A chat box on screen. Alex and Dave will be monitoring this so that we can answer your questions as we go. We just ask that you include your name and your club when submitting anything. This will help us in case we need to do any follow-up with you after the event directly about your query. I'm now going to hand over to our expert, Sabile.
Thank you very much, Nia, for the introduction, and a big welcome for me as well to everyone who's joining us tonight. As Nia mentioned, last week my colleague Elaine covered employment basics and in particular status, i.e. whether someone is an employee or a worker or self-employed. And what we are going to look at tonight is volunteers and the law, how that is being dealt with, what the legal requirements are, what a volunteer is, and then we are going to look at 0 hour contracts. Again, as Nia mentioned, if you have any questions, please put them into the chat box. You can ask the questions throughout. What we are planning to do at the moment is to deal with questions regarding volunteers when we finish that particular section, and then to deal with the questions on 0 hour contracts at the end of that one. If you have any other questions that you may want to raise, employment law related, I should add, please also ask them, and if we have time to get to them, I would see that I can respond to those as well, and otherwise we will just come back to you after the event. So let's move on to the first slide and to have a look at volunteers. Now, what is a volunteer? Who is a volunteer? Sounds easy, but in reality it might not be that easy after all. So I put a little definition on the slide there, and that says that a volunteer is someone who is engaged in activity which involves spending time doing something which aims to benefit a third party without pay, and a volunteer can come and go as they please. Now, that leads us to our first slide or question, because what I would like to know from you is what sort of types of volunteers do you have, what do they do, and what do you expect them to do? So the Slido slide is up there, so if you could put your answers in, that would be great. I know this is an open question, so it'll probably take a bit more time to put the information in. And please don't feel shy. Yep. Okay, so we've got coaches, committee members. Anything else? Team managers, thank you. Ground staff. Okay, so you have, yeah, there are a lot of things are done by volunteers. We've got caterers as well, kitchen staff, safeguarding, fundraisers, bar staff, groundsmen, refs. Thank you. Okay, I think that's a really good list of what volunteers are used for, and what I would, so thank you very much for supplying that information. So what I would like us to do now, and that is on the next slide, to start off with what sort of rights do volunteers actually have. Now, if they are genuine volunteers, and we will get to that, whether someone is actually a genuine volunteer or not. So if they're genuine volunteers, they actually have very limited legal rights. Their legal rights are limited to, again, you can find that on the slide, there is a right to work in a safe environment, and then a right for data to be processed in accordance with data protection laws. So you will see, or you can see, that that is very limited. However, those very limited rights only apply if someone really is a volunteer and is not a worker or an employee. So on the next slide, sorry, before we go to the next slide, I would like to have another Slido question, and that relates to payments. Do you pay your volunteers anything? Or do you provide them with benefits in kind? And what, if yes, or if you're not sure, please put that in. Okay, so that's 67%, no payments. Oh, that's going 75%, no payments, 20. Going back up for 33%, yes, it's going down again. I have absolutely no idea why that's happening now, but I think the vast majority says no payments. We've got some not sure, and we've got some yes as well. So let's have a look at the next slide so that we can cover this question. So, are volunteers entitled to be paid? And the answer to that is no, and they should not be paid. And I've put that there in capital letters to make that as clear as possible. Because if you pay a volunteer for what they do, then he or she is very likely to be considered to be a worker, and maybe even an employee. And as a worker or an employee, that person will be entitled to have the rights that are available to workers or are to employees even. And with regard to workers, that would include the right to receive national minimum wage, holiday pay, and the right to pension auto enrollment if the requirement is there. So can you pay? So don't pay the volunteers. Now, can you provide volunteers with benefits in kind? And again, that should not be done. I have seen it happening, say that volunteers got either subsidized travel or reduced membership fees or some sort of staff discounts. And if that is being paid, that is very likely to be considered to be payment for services. And HMRC is then likely to treat the volunteer as an employee, and that can have very serious consequences for the club. Because unless a volunteer is exempted from the requirement to receive national minimum wage, if HMRC regard them as an employee, the volunteer has to be paid the national minimum wage, and the club would have to pay arrears and may also have to pay penalties. So please do look very carefully as to whether you are paying any benefits in kind to the to your volunteers, and if you do, the answer to that, or to the next one, is actually don't. Now, what you can pay to volunteers is expenses, but you've got to be very careful that, first of all, those are genuine expenses, that they are not just a fixed amount every month, but that they represent the actual costs that the volunteer has had. Because if you just pay a fixed amount irrespective of what the actual expenses are, again, that is likely to be regarded by HMRC as payment for services, with the result that from a tax point of view, HMRC is likely to treat these individuals as employees, with the consequences that I have just mentioned. On the next slide, the question there is it advisable to have a written agreement with a volunteer? Is it required? Is it advisable? Now, it's not required, so you do not need to have anything in writing with a volunteer, but I have seen quite a few organizations who prefer to set out in an agreement what is expected, so that it is clear for both parties that both sides understand what they need to do or what they shouldn't be doing. Now, I'm always someone, I think, who says it's better to have something in writing than not to have something in writing, but there are some do's and don'ts if you have a written agreement that are very important to bear in mind. And I've listed a few there on the slide as well. So if you have a written agreement, or if you think about having a written agreement, what you should not just do is to just adapt a contract of employment that you might have somewhere in the drawer, or a Section 1 statement that's kicking around somewhere. It's quite tempting to just use that and put in volunteer instead of something else. But don't do that, because that would point more in the direction of it being an employment contract or a contract for a worker. It should be kept short, informal, and language should be used that does not make it sound contractual. So adopt flexible language such as usual or suggested, and expect and express any commitments more like expectations rather than obligations. So, for example, if you say, we hope that you will usually be able to volunteer for us for at least whatever it is, so that we can each get the most from the volunteering experience. However, we are flexible about when you work, so please let us know if you prefer a different arrangement. So everything sort of flexible, suggesting, so that it doesn't sound like a contract and contractual obligation. If you wish to refer and sort of want to define what the volunteer is going to do, or the role the volunteer is going to have, don't include a job description and do not refer to it as a job. Also, don't put any specific time frames with regards to notice, for example. Of course, you can ask the volunteer to give as much notice as possible if they want to stop volunteering, but don't sort of set any specific time frames. Don't make it sound like they've got to provide notice, and do make it clear that they actually don't have to give you any notice, because if you think back to the first slide where we had the definition of volunteer, where it says they can come and go as they like. That's the sort of characteristic of the volunteer. They can come and go as they like. So if you have a written agreement, or even if you don't have a written agreement, but you expect them to provide particular notice, if they want to stop volunteering, I would very strongly advise against that, because that might point into the direction of them being a worker or an employee with the consequences that we have already looked at. One question that we had received, and which was a very good question, is what do we do with complaints or grievances raised by volunteers? So the first comment there is that the ACAS Code of Practice on Discipline Grievances does not apply to volunteers. However, that does not mean that volunteers can just sort of fair game to everyone and can be treated horribly. I mean, first of all, from a reputational point of view, that wouldn't be a very good idea. So you must treat volunteers fairly and consistently, and it's good practice, if there is a complaint, if there is a grievance, to meet and, where necessary, to investigate, and then to explain the outcome. If you want to, you can probably even give a right to an appeal, but I would suggest that that is being looked at sort of on an individual basis. Volunteers, genuine volunteers, are not protected against discrimination unless in reality they are workers or employees. I must apologise, I sound a bit like a broken record, and I will keep saying this, unless someone is a worker or an employee, because that is the relevant thing here. If you attended the session last week on employment and worker status, you will have heard that it's not what it's called, but what a person is, the status a person has, is how it is lived in practice. So even if someone is called a volunteer, even if it maybe starts off falling under the definition of volunteers, it is possible that because of the way the relationship is being handled throughout the months, the years, or maybe even longer, that this person will have actually turned into a worker or even an employee. So whenever there is, I think in particular when there's a complaint or grievance, I would recommend that you look very carefully whether this person is actually still, when I say just a volunteer, so that you would not have to go through the ACAS Code of Practice steps and requirements. So do look at it. Don't just say, well, they started off as a volunteer, fine, they remain one, but do bear this in mind throughout the lifespan of the relationship with the employee. And that of course also applies in relation to protection from discrimination. For example, if someone raises that as if we've been discriminated against, again, you need to consider, are they maybe workers or an employee? What do we need to do? The other thing that needs to be borne in mind is that although a genuine volunteer is not protected against discrimination against him or herself, but the way that they behave, the club can be held liable and responsible for the way a volunteer behaves towards others. And that's the case even if the club's not aware of the conduct and didn't approve it. So whereas on the one hand you can say, well, a volunteer himself is not protected against discrimination, but you need to keep an eye on how a volunteer behaves towards others, because you might end up being liable for another third party saying, well, this volunteer, this club discriminated against me, and then you can be held responsible with regard to that. So on the next slide, we are going to look at how to ensure what can be done that a volunteer does not obtain employment or worker status. and we have talked about some of these things already, but I thought that it would be helpful to summarize it on this slide here. Now, it's very important to keep boundaries between paid staff and volunteers. So no payments, no benefits in kind that can be seen as payments for work. Don't pay a fixed amount of expenses. The expenses must be reasonable. So for example, if people can charge expenses, say for a meal, you mentioned, for example, that you had volunteers, you had coaches for volunteers, so if they travel somewhere for an away match, and then they can hand in expenses for the meal they had, for the lunch they had maybe after the match, would be advisable to set sensible limits, so that it's not a 5-course meal in a 3 Michelin star restaurant, but that the expenses are kept reasonable. The next point, training. Now that's an interesting one. So it's possible to offer training to volunteers without turning them into a worker or an employee, but the training must be linked to the role. So it shouldn't be training that is a sort of enticement for them to stay as a volunteer or a perk on top of it. It should be linked to the role that that particular volunteer is doing, and also continue to treat them as a volunteer. Now, we talked about a bit earlier when we looked at having a written agreement, how that agreement should be worded, and that it should be sort of suggested as sort of flexible and so on. So within that agreement, but also in reality, don't place burdens, don't place expectations on the volunteer, because if that would result in the volunteer becoming an integral part in the club, then it's likely that this person is no longer a genuine volunteer, but maybe a worker, and maybe the club should consider employing them. Now, that is all with regard to volunteers. Dave, do we have any questions?
Sybil, we have quite a few.
Okay.
I shall deal with a few of them as we go. So first of all, I've got one here. It may have been answered, but I'll give it to you anyway. What are the responsibilities of a rugby club to its volunteers with regard to employment laws, and do these differ depending on the legal status of the club? I.e. if they are incorporated, unincorporated, or have a tax benefit like a charity or a cask.
Yeah, I mean there's quite a lot in that. There's quite a lot in that question. The question of so I think the first one is, if a person is a genuine volunteer, there are no obligations and liabilities under employment law, because that person is not an employee or a worker. And as we said at the beginning, the only rights a genuine volunteer has is to work in a safe environment and rights under data protection law. Now, the right to work in a safe environment is obviously an important one at the moment. So to work in a COVID safe environment then clearly applies to volunteers as well. Now, that right to work in a safe environment, there is no difference as to whether the club is a charity or what status the club has. If that person is a volunteer, they have a right to work in that safe environment. Now, with regard to the possibility of having to pay national minimum wage, workers who are working on a voluntary basis for a charity or voluntary organisation or an associated fundraising body, they do not qualify for national minimum wage if they do not receive any payment other than in respect of expenses or any benefits in kind other than provision of reasonable subsistence and accommodation, and so on. So there is a difference where we actually don't have a volunteer, but where we have a worker who is working on a voluntary basis for charity, and under the those conditions which I've just listed, they would not qualify to be paid national minimum wage.
Okay. And if the secondary part of this, if in particular there is no formal voluntary agreement in place, I think you mentioned this earlier in the presentation, what are the club's liabilities in respect of any conflict or dispute from a volunteer?
When you say so, I'm assuming that with conflict or dispute is that either the volunteer is not happy with what is how, the way they're being treated. So as I said, the ACAS code doesn't apply, but the club should look at it, investigate it, speak to the volunteer, and explain the situation. Now, if the volunteer says, well, actually, I'm not a volunteer, I am a worker or I'm an employee, that's clearly something, again, as I've said, that the club would need to look into. It then would need to be considered whether having the label of volunteer is actually correct and does reflect what's happening in reality.
Okay, yep, okay. Also, it should be in the club's constitution in terms of of how those things can be dealt with. I've got a couple that I'll just take out of the chat function, but I'll come back at the end if I've missed any. Just a couple. This has come up a couple of times. What is the legal status of awarding an honorarium, which I assume is to a volunteer?
I must admit, I do not know what in the club's constitution an honorarium would be. I'm assuming that is something that would be dealt with in the constitution. I think, again, from a legal point of view, we would need to look at the whether that is someone who provides, who falls under the definition of volunteers. But if they do more than that and fall under the definition of worker, then they would be a worker or an employee.
Okay. Well, perhaps I might pick that one particularly up afterwards and see if we can get some further information following the webinar. And there's quite a few that popped up when you were talking about material benefit. You know, a number of questions here. What about special membership rates? What about stash, i.e. branded clothing, free of charge membership, discounted drinks, etc.? Do each of these need to be treated on an individual basis, or is there a sort of a general principles from HMRC of what is considered a material benefit?
Yeah, I would say that if there are reduced membership fee discounts and so on, I think that's likely to be regarded as a benefit in kind for payment, and then regarded as payment for services, with the result that HMRC would treat that person as an employee. Maybe, I don't know whether everyone attended the session last week, so just quickly to explain that under employment law there are three possible statuses: employee, worker and self-employed. So worker is that sort of weird hybrid status in between, but as far as tax law is concerned and HMRC is concerned, they only have two categories. One is employee and one is self-employed. So that's why when I talk about HMRC likely to be treating a volunteer as an employee, that's the reason for it, because HMRC does not recognize that status of worker. So for them, you're either an employee or self-employed. So that's why I use the word employee there. Yeah. So coming back to the benefit one, I would be really careful with that. With things like the membership fees and the discounts. As far as uniforms are concerned, it's possible for volunteers to be asked to wear uniform, but in the context of others, if employees and so on so if it's common to wear uniform, so to wear shirt, wear the kit and what have you, so that it's a usual thing to do within the environment, and the volunteer will fit in. So that should be fine. The next question there is then, what about the payment for that? Would that be regarded as a benefit in kind? Regarded as payment for services if they can take it home? Maybe, but that's a question for a tax lawyer. I'm very happy to ask one of my very clever tax law colleagues to give us a response to that.
what I'll do for the colleagues that are listening, we will put something in terms of we've done some material benefit work in relation to a different area. I'll get that posted, and then we can take that. I appreciate that was more of a tax loaded question than it is illegal. Thank you, Sybil. We can move on for now.
Okay, so let's move on to 0 hours contract. So what is a 0 hours contract? I've put a definition in there, and because that's a definition in the Employment Rights Act, it probably sounds more complicated than it should be, but what it says is that a 0 hours contract is a contract of employment or other workers' contract under which the undertaking to do or perform work is an undertaking to do it conditionally on the employer making work or services available, and that there's no certainty that any such work or services will be made available. So the key point there, or the key aspect of a 0 hours contract, is the absence of mutuality of obligation. So that means that the employer doesn't have to offer anything, and the employee has the right to say if the club does offer work, to say no, I actually do not want to do that work. Now, what a 0 hours contract isn't is something totally separate from sort of an employment contract or a workers' agreement. I sort of sometimes get the question there, well, we'll do a 0 hour contract that has nothing to do with employment law, there aren't any rights or liabilities, and so that's the sort of panacea for all our problems. And the answer to that is, and let's have a look at the 4th slide or question for that, please. So that question is, a person working under a 0 hour contract can never be an employee, true or false? Perfect. Wonderful. 100% says it is false, and so I think I can stop my presentation here because everyone knows everything about the 0 hour contracts anyway, because that is exactly the right answer. Of course, someone under a 0 hour contract can be an employee, because there is a lack of mutuality of obligations in most cases. The individual will have the status of worker rather than the status of employee, but there are employers, and I have clients like that, who do prefer to confer the employee status on the 0 hour employees rather than having them under worker status. So let's move on to the next slide. So we know now that 0 hour contracts can be either employment agreement or worker agreements. So what is the contractual structure of a 0 hour agreement or 0 hour contract? So they are not always called 0 hour contracts, so they can be called sort of casual work or as required, flexible work. So those other words or phrases are often used instead, but that then still means it is a 0 hour contract. And if someone is a casual worker, that's not a separate category of a status that someone can have. A casual worker is a worker usually under a 0 hour agreement, and then depending on how it works in practice, that person is an employee or an individual, or a worker. And under the mechanism, as we've said before, the employer or the club says, well, here I have the work, and then the individual can accept that or not. Now let's have a look at the next slide, and that will give you some information about what what sort of paperwork, what sort of documents you should be providing with regard to 0-hour well, individuals work under 0-hour arrangements, and that since April, 6th of April this year, which went sort of slightly unnoticed, I suppose, because of the pandemic we are in, workers always also have a right to receive a written statement of their particulars of work when they are taken on. That applies to existing workers. Sorry, that applies to new workers and workers who are already workers under 0-hour contracts. They are not entitled to receive that written statement until they are first engaged or rehired under a new contract or after that 6th of April 2020. So you can see on the slide there what usually is in this type of document. So it's the status of the individual, then the employer's discretion to offer or not to offer work, the mechanism, how to offer and accept, the terms that will apply to each job or assignment, and it now continues on to the next slide. The nature of the work required, the hours, individual entitlement to pay. Then there's some sort of boilerplate provisions which I'm not going to go into now, and then something about termination provisions, and we will look into the last thing there, the termination of 0-hour contracts, a bit later on. So just again, because it's so nice, let's have a look at the legal status under 0 hours contracts. We can go through this fairly quickly. Employee, worker, self-employed, shareholder. The last two options are not relevant really here, so I'm not going to deal with those anymore. And we can look at the next slide now, which is a slight repeat, I think, with regard to legal status of what was covered last week, but because it is so important, I wanted to mention it here again. With regard to the volunteers, I've already mentioned that it's not what's on the tin, but actually what's in the tin. So what is there in reality? So to determine whether this 0-hour contract person is an employee or worker, that's not a mechanical exercise. So it's not a sort of running through items on a checklist. It's to paint a picture. So you as a club, and ultimately if there was a dispute, an employment tribunal would look at all the detail, the way this relationship is lived in practice, and then it's a matter of evaluating the overall effect of the detail, and that can only be done by standing back and sort of looking at it from an informed, considered and qualitative appreciation of the whole picture. And again, as I said before, with regard to the volunteers, it is important not just to do that at the beginning of the relationship, but to continue to do it throughout. Now, if we could have a look at the next slide, it is mentioned there in particular that it is possible for the relationship to change, and that therefore it is important to watch out and monitor what is actually happening. Perfectly feasible that someone started out genuine 0 contract arrangement, but then over time, because of the way of what's happened, this arrangement could have turned into a sort of proper employment contract. So, for example, if the individual is given regular work each week, so it's always the same days, although the amount of work may fluctuate. I think we looked at about bar staff and so on was mentioned. So if there's someone behind the bar who does the bar every Monday, every Tuesday, year in, year out, and where sort of over the time it becomes an understanding that Bob, or whatever Bob or Mary are called, that they will spend at least 2 or 3 hours behind the bar every Monday and Tuesday, then that could mean that there is no longer a lack of mutuality of obligation, but that there is actually an obligation for Bob or Mary to be behind the bar every Monday and every Tuesday for 2 or 3 hours. And that would then potentially be enough for that relationship then to turn into an employment relationship rather than a worker relationship, where the person, or under the definition of with this lack of mutuality. What I've also seen in some contracts is that an employee might be required to be available for work, except where they have given advance notice that they will not be available on a particular day, and that means that the employee cannot refuse work on that particular day unless they sort of have pre-booked the time as not being available. Now, if that type of arrangement is in the contract, that constitutes an obligation on the employee to accept work. So that would mean that in that situation, the contract would not be a 0-hour contract, because there is an obligation for the employee to accept the work. So under the 0-hour contract, and that's on the next slide, there is a sort of brief list of what, if that person is a worker, what rights that 0 hours worker has. That's the right to receive national minimum wage. That individual is protected in case of them blowing the whistle. There's protection against less favourable treatment because they are working part-time. Protection from discrimination, that's different from the genuine volunteers we discussed earlier. And also very important, there is a right for paid holiday and rest breaks. Now, calculating holiday entitlement for a 0-hour contract worker can actually, well, can be a nightmare, is a nightmare, because what the worker must be paid for is, so for holidays they actually take, they must be paid at the rate of a week's pay for each week of leave, and the 0 hours worker will have no normal working hours, so that means that the week's pay is calculated as the average weekly remuneration over the previous 52 complete weeks, counting backwards from the first day of holidays. Now, and if that person has not worked yet for 52 weeks, then the calculation should be done for the period that they have actually worked, and only the weeks are taken into account in the weeks that they do actually work. Now, we are there have been attempts sort of trying to make it easier, i.e. to use sort of percentages to calculate the holiday pay. However, we have a decision there at the moment which is with the Supreme Court. That's the case of Brazil and Harp Trust, and in that case the Court of Appeal decided that the percentage calculation should not be used, but that other calculation was sort of going back the 52 weeks, and we need to wait and see what the Supreme Court says there, which calculation should be used in order to calculate the holiday pay. Fifth slide or question in this context is the following. Is a 0 hours worker entitled to statutory sick pay? Okay, yeah, 100% say no. And the answer to that is, I'm going to give you a very legal answer first. It depends. And I'm now going to explain why it depends. It is under certain circumstances possible that a zero-hour worker is entitled to receive statutory sick pay, because in broad terms, anyone who is paying Class 1 national insurance contributions will qualify for statutory sick pay, regardless of whether they are an employee or a worker for other purposes. The law is not making it easy here, because there are different definitions. I already mentioned the slightly different status definition and distinction under tax law. And again here, the definition of what counts as an employee who's entitled to receive SSP, so statutory sick pay, again is a different one. So what one needs to look at is whether that person is entitled to be paid Class 1 national insurance contributions. However, that's not the only requirement. There are also minimum earning requirements and too many other exclusions for us to go into in detail now. But suffice to say that, for example, someone working under a 0-hour contract, they may not qualify for SSP, for example, if they're not qualifying employees between assignments, or if they don't have the relevant level of earnings to qualify for SSP. Now, to try and work out whether any particular 0-hour contract worker is entitled to SSP, that's again a bit of an administrative nightmare, and does put quite a burden, obviously, on a club to try and work that out. But it is something that needs to be done, so that you don't fall foul of the law. Now, last but not least, is the interesting question of termination of 0 hours arrangements. Now, as there is no obligation to offer work, there shouldn't be any requirement to give any period of notice. And that means that ultimately what, as a club or any other organization who have 0-hour contracts, can be done is just sort of to leave it. So, you know, there isn't any more work, we just leave it. That's also interesting and important, and we've had that question in particular now in relation to furloughing 0-hour contracts and what to do after furloughing comes to an end. What do we do with, if we have 0-hour workers or on here? Are they, and if we now have to make on here, I mean on the furloughing scheme, if we now don't need them anymore, do we have to make them redundant? And does that mean are they entitled to redundancy pay, which they would be entitled to after 2 years of service, or do they even have unfair dismissal rights, which again an employee has, not a worker, an employee. So we there would be looking at, is this person a worker or an employee again? Do we need to follow a process? Do we need to follow a procedure if there is a risk that someone is an employee, to make sure that making this person redundant would not be regarded as an unfair dismissal? Now, it's a slightly tricky grey area, but our advice there would be that it's better just not to engage the individual anymore, because if there is no clear act of termination, then it's difficult to see how a tribunal could treat that as a dismissal. So the safer option looks like would be just to let it lie and to not engage anymore. Again, I'm coming back to whether someone in reality is a worker or is an employee. It needs to, so what I've just said, if you find yourself in the situation where you have to make 0-hour contract individuals, I call it redundant now in inverted commas, it is important to consider in individual cases whether this particular person might be an employee with employment rights, in which case you have to follow a fair procedure and you potentially have to pay redundancy payment. Whether someone, even if they are employees, have 2 years continuous service in these 0-hour situations is also an interesting and can be a complex question. Again, I think Elaine dealt with that last week, but just to repeat, that usually where there's a break of 1 week or more between assignments, that will break continuity, unless the arrangement, unless there is an umbrella contract or the break in continuity is seen as a response to a temporary shortage of work, or because of an umbrella arrangement, this person is an employee. So to repeat, in every individual situation, these issues need to be considered. Now, I mentioned earlier when we looked at what should be in that written statement, one of the bullet points said termination provisions. So bearing in mind that it's probably better just not to engage anymore, there shouldn't really be any actual notice provisions, so notice to end the contract provisions, but provisions that can be in the contract and can probably be quite helpful is that an employee should give notice if they want to have their name removed from the list, and also provision that possibly that the club can remove the name of the particular individual from the list of 0-hour staff at any time. Or also, and I've had that as well before, where someone successively refused to accept work, that under those circumstances might also be possible to remove someone from the list. Now that gets us to the last slide. What next? What next is to review the arrangements that you have, to make sure that individuals are properly identified and categorized as employees, workers, genuine volunteer self-employed people. Are there contracts, are the correct documents in place? Also, as I said before, when it comes to the identification or categorization of people, look at it throughout, not just what it was at the beginning, but what is it now? Has it maybe changed over time? And then when people are correctly identified, then to go through the rights of, say, workers and so on have, and make sure that obligations like holiday, national minimum wage and so on are met. And that would get us to more questions if there are more questions.
Thank you, Sybil. Yes, there are a couple which I'll pick up. There is a few in there which I appreciate are more tax related, so I shall leave those to answer from a different angle. But the first one, which I'm probably going to answer at the same time, but I think it was in the chat function. A number of people asked if we've got any template 0 contract hours contracts we could use as baseline, or various templates. I think Alex has put up to the chat function that you can get those on the Owen Mitchell portal, and we'll also on the screen at the moment is all the information and the help that is there. So that's a bit cheeky of me to ask and answer my own question, Sybil. So I'm going to come back with an interesting one that was popped in towards the end. It's in 2 parts. Question that was asked: I have seen advice on 0 hours that says that if you do not offer work for 8 days, i.e. 1 week and a day since the last offer, the 0 hours contract is terminated. Thoughts on that?
Dave, you were fading in and out, but so if I could just repeat the question.
Yeah.
The question was that if if no work is offered for 8 days,
Yeah,
then the 0-hour contract comes to an end.
that's what it says. Yeah,
Okay. I don't think that is the case unless there is some arrangement in the particular contract. I think what that might refer to is that break of 1 week, the break of continuity, which I refer to on the when we talk about the penultimate slide. I think it was that maybe that might cause a break in continuity, which then would result in that particular person not accruing continuous service. But so that's, I think, what might be the reason behind it. But I would not say that generally if there is if the club doesn't offer work for 8 days, the whole 0-hour arrangement is finished, unless that's what it says in the contract. I would not say that is correct.
okay. Another one from the same person. I understand that that 0-hour concert did not have the right to a tribunal unless it is a case of discrimination.
Again, I think the first answer is it depends. It depends on what status the 0-hour contract individual has. If that 0-hour contract individual is a worker, then they have some rights, but fewer rights than employees have. If we could go back, please, onto slide, I think it is slide 18. Is that possible? Where we list the rights of workers. If not, doesn't matter, that I can just explain. On that slide, it does say that a worker is protected against discrimination. So as a worker, that person can go to the tribunal to claim that they've been discriminated against. They can also claim that they have suffered a detriment because they have blown the whistle. They can also claim that they have not been paid sufficient holiday pay, for example. If the 0-hour individual is more than a worker but is an employee, and if, for example, they can go to the tribunal saying my rights as an employee have been violated, and for example, if that employee, 0-hour employee, can say that they've had 2 years continuous service and that the arrangement has been ended and that was a dismissal, then they can potentially say that that was unfair.
Okay, I've got a couple of others. I've got one which is if you ask a volunteer to sign a code of conduct or a code of conduct for volunteers, is this a contract?
No, I don't think so. I mean, I don't obviously know what the code of conduct looks like, but what I'm assuming is that it is a list of rules and guidelines as to how someone should behave, and I think it would actually, so I would say if that's the case, if it's rules and guidelines of behavior, then I don't think that would be regarded as a contract, and I don't think that would necessarily mean that person was not a genuine volunteer. In fact, I think it's probably quite important that volunteers are aware of these code of conducts, because again, if you think back to what I said when we looked at volunteers, it is possible for a club to be liable for, say, if volunteers behave in a discriminatory way. So it is important for the club to make sure that the volunteers know how they need to behave.
Okay, couple more. If someone has a contract that doesn't mention the number of hours to work, i.e. a coach, but is being paid, are they a worker or an employee? I know that's a bit of a hard question just to throw at you, but it's kind of what sort of things do we need to think about in that? So if someone has a contract but they don't have the number of hours specified?
Well, I mean, even in a workers' agreement, the hours should be specified. I think what we need to understand, the fact that the hours are not specified doesn't mean that someone is not necessarily an employee. All it could mean is that the contract does not have all the elements in it should have in it. If the coach is, or if the way this operates is that it says, well, here, coach, when we will tell you what, I don't know, every month or week or what have you, that you have to coach this team on that particular day, take it or leave it, then, and the coach can say, well, actually, no, I don't want to have this particular assignment, then I would say it's probably a worker agreement. If it is a coach who is required to coach every Saturday, every Sunday, and they're not just volunteers, then it could be an employee. I think what we would need to know what's happening in reality rather than just looking at what is in the contract or what isn't in the contract.
Okay, thank you. And I'll do one final question. And just say to the guests this evening, if there's any questions not answered, we'll try and pick them up when we come back out. Last question, and it's the last one on the list actually. If a worker worked without a signed contract, does he or she have any rights? And if we now offer them a 0-hour contract, does past service count?
Yes, the fact whether someone has so there is a legal obligation to provide written statements of employment, written particulars of employment or worker arrangement, but if there isn't anything in writing, that does not mean there isn't a contract. So there can be a contract between the club and an individual, a legally binding contract, either an employment contract or workers arrangement, even if there isn't anything in writing. And also that particular individual can have acquired continuous service irrespective of whether there has been something in writing or not.
Okay, thank you, Sybil. And thank you all the volunteers that have signed up this evening. As you can see, the final slide there at the moment is gives you information in terms of the RFU Legal and Tax Helpline, which is run by Erwin Mitchell. It's got the portal and template documents, which again includes the 0 hours contracts, and then obviously there's a link to some of the other information that we have on the website, which Alex has been posted in the chat function throughout. So this webinar has been recorded, so you will get a copy of it, and obviously we will try and pick up on some of the questions, certainly the ones more tax related, following this. So thank you, have a good evening, and hopefully I shall see you tune in again soon.